and I fucking love it. It's an affirmative defense.
Action and avoidance. It's beautiful. It puts the onus of probandi back on them. Now, what I suspect will happen is more than likely they will mail him a driver's license and say, oh, no, we've reversed this decision because they need you to be contracted with them. They're a private for-profit ad hoc corporation selling your private intellectual property for profit and gain. That's what they do.
So you got to send them something along the same vein? That sounds genius.
People say rescission or to rescind. I do a rescission, termination, and revocation of election. See, I elected to get the estate a driver's license and lend my consciousness and ability to that license, right? And if I elected to do that, I can do a revocation of election to terminate any agreement between us. When you sign on to that driver's license, it tells you that you must abide by the rules and regulations of the DMV and of the Motor Carrier Safety Vehicle Act. So you'll wear your seatbelt, you'll abide by the road sign indicators and stoplights and all that stuff, right? But if you don't have a contract with them, well then the state police, the sheriff's department, and the police departments, they all just lost jurisdiction because what they're enforcing is a contract. Well, that presupposes because when government gets involved, officers will always say, well, I can't get involved in the matter because it's a civil matter. Well, that contradicts exactly what you do as a motor vehicle code enforcement officer when you're working on behalf of a private for-profit corporation known as the municipality or the city or the county, and you're generating revenue for violations of ordinance. So where is your contract between the city, the county, or the municipality and the DMV or BMV, right? Because if I call the cops on somebody and I say, hey, I put my couch in their house and they won't let me get my couch back out, they'll immediately say, well, that's a civil matter. We can't get involved in that. Well, okay, well, how are you guys involved with a civil matter wherein the DMV would be the one that would be making the claim that I violated stuff, but you're not even authorized by the DOT to make traffic stops, right? Because the Department of Transportation is responsible for the Motor Vehicle Safety Care Act, and there's only a few qualified DOT agents to even be out there on the freeways, highways, byways, and passages to pull people over for motor vehicle violations.
Correct. And like you said, they need a contract. And, they kept trying to tell me, the part that flipped me out, they kept trying to tell me that I didn't have a contract, that driving was a privilege, it's not a contract.
They're right. Hold on, wait. They're right when they say driving is a privilege. They're absolutely correct. Driving is a privilege. Traveling, on the other hand, my private household consumer good, primarily used for household purposes, is an unalienable right, so basic it need not even be mentioned.
You can't even say travel. He slapped an obstruction charge on me for saying travel.
Who did?
The guy who pulled me over, the state trooper who pulled me over, he immediately said, when I told him, I said, sir, I'm not, I was with my wife, she got cancer, so that I got a little nervous. And I was like, sir, I'm not driving, I'm just traveling with my wife to take her to get some things, and he said, oh, we're not going to do that one. He immediately went to his radio and said, we got a sovereign here. Mm-hmm. And then they went from there.
So at that point, you realize that if you go to their corporate charter bylaws and articles of incorporation, you will be able to find in the first 3 to 4 paragraphs, if he's working for the state troopers division, you'll find in the first 3 to 4 paragraphs where they are bound by the constitution for the state of whatever state you're in. And then you go to what would be the same as Article 1, Section 4 of the United States Constitution, where you have the right to be secure in your papers, houses, persons, and effects. And then you go to what would be known as the Fifth Amendment in the federal Constitution. Find that in your state constitution, where it says that you cannot be deprived of your life, liberty, or property without just compensation. Each state has both of those, which I just mentioned, and then you bring a claim against him for violating your unalienable rights and taking his income under false pretenses, which is unjust enrichment. So,
Yeah, Title 18, 241, 242 lawsuit.
you could do it under the civil rights. I'm really opposed to the civil rights. I move a little bit differently than most. It's not that I'm going to say that you shouldn't do it that way, but civil rights are something that the society, if you will, quote unquote, for lack of better explanation. So those who create the laws are the ones that are covered by those laws, okay? And they're more stringently bound by those laws because they're part of that association. We as men and women have an ability not to participate with a group of people, no matter how small or how large they are. We are free here, free meaning free from the legal constraints of another. So although a good majority in society believe that everybody has to do a driver's license, show me in the law where it requires that I obtain one. And furthermore, if it's required of me to obtain one, why didn't they give it to me? If it's mandatory I have it, then why didn't they freely issue it to me? Instead, they say that I have to go enter into a contract and get an application in order to acquire a driver's license, which means that the DMV is selling me a product that they created, and I am giving them my life's valued source energy in the form of an application for which they're monetizing. So last time I was in court, and this was just 2 months ago, mind you, the prosecuting attorney said, well, you were pulled over for driving without a license, driving without proof of insurance, driving without registration, and failure to wear a seatbelt. And I said, okay, whatever. She goes, I'm going to give you the same options I give everybody else. You can go get a driver's license, and I'll just drop everything. And I said, you know what? I conditionally accept your offer to go get a driver's
Yeah, I
license.
heard that. I heard you say that earlier.
I can remain an honor so long as that man, and I pointed at about 33 angle, and I said, the judge, and then I pointed clear at the ceiling, and I said, this court will order me to go get one. And he was like, there's no way in hell I'm ordering that man to go get a license. He wouldn't order me to do it. And I said, well, under the circumstances, if you can't, look, this is my ideology behind this. Under the circumstances, if you can't order me to go get one, then you can't rightfully punish me for not having one. See, you just lost your ability to enforce any infliction of anything on me, because if you don't have the ability to order me to go get one, and you don't have the ability to just give me one, well, then you can't punish me for not having one. You'd be forcing me to enter into trade and commerce and contract with the DMV, which means you would carry the primary active degree of fault for forcing me to engage in a contract for which I didn't wish to engage in. Furthermore, if I do go get a driver's license, the next question that becomes that comes to mind is, who am I gainfully employed by? Who do I send my invoice and my bill to?
Derek.
So that's why the judge doesn't want to order me to go get a license, because he knows that I'm going to invoice somebody. I'm going to bill the fuck out of somebody.
Derek, have you ever looked up the word, Googled the word license? It says freedom to behave as one wishes, especially in a way that results in excessive or unacceptable behavior.
Right. A license is to give, in Black's law, is to give somebody the ability to do something that would otherwise be illegal. That's why it requires insurance, because you're all engaged in criminal activity and you must be insured.
It's a voluntary program, I believe is exactly what it says in there. If you look it up.
If you're a bad criminal and you keep getting dinged on your insurance, guess what? They don't let you be a criminal anymore, and they take your license, so you don't have a license to be a criminal. That's what it is. That's what commerce is. That's the whole commerce game. It's a license to be a thief, a hood rat, a conniving son of a bitch, and you can hide under the guise of, I was just doing my job. It's all bullshit. That's why they have to have insurance, because they're engaged in criminal activity. And they hide it under the guise of statute at large 411, where the president says that everybody must be licensed. I always like the cops to tell me, you can't drive without a license. And I go, I agree. And they go, what? Yeah, I agree. Can't drive without a license. What evidence do you have that I'm engaged in commercial activity? Title 18 USC 31 subsection 6. Definition of motor vehicle is a motor vehicle that is being used to haul passengers, services, or goods to the highways, freeways, passages, or byways for commercial purposes for profit and gain. What evidence do you have that I'm engaged in commercial activity?
You go to the DMV, you can get what's called a
driving.
Visor card.
Go ahead, Dave.
I said, if you go, I think it's the DMV, you can get what's called a visor card, and that's what cops are supposed to have in their cop cars, which depicts what a commercial vehicle is.
Except for local PD and sheriff's departments are not authorized by the Department of Transportation to even interact with you in traffic stops. That's a violation in and of itself. They're not qualified. They don't have the proper training. See, I already have my DOT number and all that good jazz. And I've already talked to the DOT in Washington, D.C. And then I talked to the DOT, the INDOT, which is Indiana Department of Transportation. They're like, well, you're way over our head. You're already talking to the federal government. And the federal government is charged with the duty of protecting my unalienable rights. So then they directed me to state troopers. Well, the state troopers didn't want to talk about it. So then they directed me down to the BMV, and I took a $5 million bond down there. And I took my memorandum of law on my private household consumer goods, which is a GT Mustang, and I told them, look, I don't plan on delivering pizzas with extra anchovies, and I'm not an Uber driver, and I'm not going to be hauling passengers, people, or services down the freeways, highways, and byways for revenue or the purpose and intent of generating an income. And they're like, sir, we know what you're trying to do, but this is way over our heads. We're going to have to send this to our attorneys in Indianapolis. And I said, oh yeah. And then I asked him, would it be by chance, would the attorney general be involved in this or anything? I'd be more than happy to facilitate and assist and help, because all I want is an exempt plate issued. It's an exempt plate that says private. It doesn't require a tag. And when the cops get behind me, it says private household consumer good when they run it. And they know that it's outside of their jurisdiction. That's all I want. And they were all just smitten with everything. But of course, I have a lot of documentation that goes with it too, and case precedent and supporting law and everything else. So I don't do things half-assed, just like Leah doesn't do things half-assed. I have a beautiful layout on this. So,
hey, Derek, I really appreciate all your what?
I'm sorry. I just want to add that last question. Would these letters, as far as the DMV, would that go to the commissioner? That's what I sent it to.
To the DMV?
I mean, as far as, having some sort of response, will it go to the commissioner?
Find out who the agent for process of service is, but like with the DMV in Nebraska, what I did was I got a hold of LaRonda Lamb, who was the head of the DMV in Nebraska. And I asked some simple questions to her and waited for her response, which I found really intriguing. Am I required as a man to get a driver's license? Yes or no? And of course, I answer that question for her, knowing that she's not going to respond back. So, if you fail to respond in 10 days, we will agree and stipulate that I do not, as a man, have to get a driver's license. And then I sent her another correspondence that said, as a man, am I required to register my private automobile? Yes or no? And your failure to respond, we will agree that I am not required to register my private automobile. So I entered into this series of letters back and forth, correspondence back and forth like that. And what was funny is she would write me back really encrypted. If you are driving a motor vehicle on the Nebraska State Highway pursuant to Nebraska Revised Statute, you are required to have a driver's license. Do you notice how she omitted and evaded and avoided my question? My question didn't have anything to do with motor vehicle. What are you throwing motor vehicle at me for? Remember that maxim I read this evening that the law is very difficult because it can be overthrown at any time based upon and predicated on definitions. If we don't have an agreement on the definitions, then we don't have an agreement. We can't have a mutual ascension of the mind, which means we don't have contract. And so, that's how you deal with these things.
So that you find the head of the DMV, not the commissioner. Isn't the commissioner the head?
I don't know. I don't know what state you're in.
I'm sorry. I'm in Georgia. the governor elected a commissioner that runs that division.
Yep. And what you have to realize is that you entered into a contract, and as soon as you terminate that contract, you got to let them know the terms and conditions of the termination of the contract. Hey, if your record that you maintain after this fact causes me harm, damage, injury, and loss by gun-toting morons pulling me over on the side of the road, alleging that I'm a delinquent driver or whatever after I've done a revocation of election and a termination of the contract, and I've told you to clear my private intellectual property out of the database so I'm not cause harm, damage, injury, or loss, you carry the primary active degree of fault every time I get pulled over. And it comes to the nominal fee of $250,000 per occurrence per agent per day, right?
Wow, it sounds like you just jumped on my document. That's exactly what it says, except for it says 200,000, not 250. But that's exactly what I sent already, and because I'm not the jail type of dude. I don't feel like going to sit in no jail. I just want to leave me alone.
Freedom isn't free. Freedom isn't free, and you got to fight for it. I spent a lot of days and a lot of nights in jail. I've been to prison 3 times, and look, I'm not joking. I've been to prison 3 times and never greater than a 16-day stint. But they sent me there to scare the shit out of me. And when they figured out that didn't work, and it just pissed me off, well, then they. It's a different thing. So I can't tell anybody what you can or can't do. I can't tell you what can or what will or will not work, because look, you might get a judge that hasn't gotten any warm apple pie in 6 months, and he's feeling like an arrogant asshole. Maybe he's got a toothache that day, and he just don't like the way you look at him. And fuck you.
Well, one thing you taught me earlier today is I'm not gonna say that I was what'd you say? Not damaged. The other word. You told him that you weren't. And then you said you agreed to it. What'd you say?
Oh.
You told me that you weren't damaged or that you had been harmed. What did you say? What is that you said that landed you in jail?
Oh, when I got the suit that I was bringing against an entity.
When you said that you had suffered. Yeah, when you suffered.
Yeah, suffered. Yeah, I definitely won't tell him I suffered. I definitely use the word damage. Yeah.
Hey,
Yeah,
I just looked up. King, I just looked up the Georgia Commissioner of Agriculture. It's Tyler Harper in Georgia. If you want to look him up, Georgia Commissioner of Agriculture, Tyler Harper.
Commissioner of Agriculture. Okay, thank you.
Well, but you need to terminate your contract with the DMV. Is it the DMV or BMV in Georgia?
I think it's a DMV.
Yeah.
I think they call it DDS, driver, domestic service or something like that. Driver service. I forget what the first D is for.
Now, here's a question for you. Do you actually drive for a living, like Uber and stuff? Because that would cause a conundrum for you.
Not at all. I listen to y'all for a living right now.
Then you travel, because think about a driver.
I travel. I only travel.
Yeah. Drivers are going to be like Uber, people.
Saying that they have an ethics requirement. Bar grievance, court watchers.
Yeah, that's why I had no problem giving it back. I thought I had no problem giving it back to him, and then I realized I had to travel even further. I had to get on the plane in 2 days. And I ended up having to go back and get an ID so that I could get on the plane.
Right. I was just going to mention that. And it's even articulated, I believe it's in Arizona, that if you opt not to get a driver's license, you can get a state ID. The state ID is not a driver's license, but when you get pulled over with an ID, they realize that you're not a commercial driver. And so there's an exemption there. For people who
passport too.
Mm-hmm. But again,
got a problem.
There's so much disdain for people who just want to be free, and I find that people who seek to oppress others have taken an oath in the military to protect our freedom and have come back and been ostracized for being gun-loving Americans, and at the same time will club you in the back of the head and violate the Geneva Convention under the rules of warfare and they will shoot an unarmed man in a heartbeat. Now, if you were to shoot an unarmed man over in Afghanistan during time of war, your ass would be in fucking Leavenworth for murder. All right, because you're not allowed to engage until engaged upon. That's the operation, right? But somehow they get back over here in the home of the brave and land of the free, and they're shooting unarmed 12-year-olds in the back of the head, claiming they were scared for their life.
Yeah, but the difference is we don't have a nationality. The difference is, especially me, we don't have a nationality. We're nobody to them, so.
Look, here's the issue with that whole ideology of you need a nationality. They're allowing military-aged men to come by the hundreds of thousands, even flying them into this nation, giving them $5,000 a month on a fucking EBT card or credit card, whatever they're doing with a phone, and they're putting them up in hotels while we got homeless veterans that are on the fucking streets, which is absolutely fucking disgusting. And that's where my give a damn and my give a shitter got broken. I was like, you know what? Fuck it. I'm going to create my own instruments. I'm going to do what the fuck I want to do. I'm going to support this country and the communities that I'm in. I'm going to issue these fucking negotiable instruments for the greater good of mankind. And if they got a problem with it, fuck them. Here's to me. So that's where I'm at. And that's why I err on the side of caution of telling anybody to do things, because I'm doing things right now behind the scenes, but I ain't telling nobody about it because I don't want them to burn with the same passion and fuel that I have without having the ability to defend themselves either. They could be thrown in prison in the next fucking 6 weeks for some of the shit I'm doing. I don't care. My give a shitter is broken. Most days I don't give a damn, and if I gave a fuck once ever in my life, I can assure you it was just once.
Hey, Derek. Thank you for your wealth of information. I want to revisit something you mentioned earlier with Lee, and the other gentleman that was there was talking about it. So just to give you clarity, I have an automobile that I want to do some administrative work that I financed through a car dealer. The bank has it. Some of all finance charges wasn't in it, but I didn't know if I needed to try to rescind the contract, or do I can do an allonge to the original contract, or how do I go about?
Are you saying the bank has it because it was a repossession?
I'm sorry?
Are you saying the bank has it because it was a repossession?
Oh, no. I'm asking you, who do I go to? Because you mentioned it with Lee about acquiring a vehicle. You were saying you could go through the process, but my contract, I was reviewing my contract, so...
Pay the invoice for the lender, pay the security agreement to the borrower, and be done with it. Give them the instructions.
Okay, say that one more time, please.
Qualify your endorsement. Pay the invoice to the dealer, pay the service agreement to the borrower, and be done with it.
Okay, because I'm already into the contract for about a year. I've owned the vehicle for about a year.
You can still launch a note giving instructions. There's nothing that stops you from doing that. It's a unilateral contract. You're the only one who signed anything on that thing, and you were never compensated for your over-the-counter security, and the dealership was in breach and in default within the first 24 hours for not giving you the proceeds.
Okay, so this is that 72, 10, 15 thing you were talking about earlier. I'm just trying to capture all this information.
Process. What I'm talking to you about is amending your instructions that need to be allonged to the note. You're going to give them instructions to allonge. So you can take a certified copy. Excuse me, it doesn't even have to be certified. You can take a copy of your note, okay, and the security agreement, and you can write on it, pay the security agreement to the borrower, and and then on the invoice, pay the invoice to the dealer, and you can mail those off, telling them to correct and amend the record, and zero balance the account, and issue a release of lien on all tangible and intangible property immediately. Right. You're balancing the account. You're settling the debt. You're giving them the instructions that they need to settle the account. And if they fail to do it at that point, now they're derelict in their duty as a fiduciary. That's everything that McReal's telling everybody. I mean, he's spot on with that. So you're really not going to get anything different from me on that account because he's correct. You can allonge that instrument and your intent at any time, one, because of their failure to perform, and two, because you're the only signator to the contract, which means they're the holder of your asset, and you're still the holder in due course, holding all rights, titles, and interest.
So I take my original contract, and that allonge goes to the bank. In other words, the one who has that security.
Yeah, well, at this point, it might be at a servicing company. So let's say you got an alleged loan through Wells Fargo, but now Bank of America is now the servicing company. So I put them both on notice. I put the dealer on notice.
No, it's just one. The company that financed it is just Ally, so they're the ones who have.
Yeah, as far as you know, they don't necessarily tell.
As far as I know, so I just start with Ally, and I send that allonge or take that contract and take the instructions that you just gave me, which I couldn't write down fast enough. But
pay the security agreement to the borrower, because you're the borrower. All right, allegedly. Paying the security interest to the borrower, and they would pay the invoice to the lender, and it's done.
Okay.
Done.
Right.
It really is that simple, and people make it way too difficult. It really is that simple, and if they fail to comply, then you're going to have to bring an action against them for dereliction of duty, breach of trust, and breach of.
Derek, this is B Wade again. I'm back. I actually did that. They failed to comply, and so that's why I took them to arbitration. I took the dealer and the alleged finance company. The dealer immediately filed for bankruptcy.
Yeah, that's because he's trying to hide them assets before you have a security lien interest in them. He's liquidating.
But little did he know I knew to slap a proof of claim against them.
You already had a UCC one in place showing interest in the assets of the company.
Yeah.
Awesome. Good for you.
So now I'm reconfused. What do you mean he's had a UCC one? Do I need to file a UCC one?
UCC one is just a notice of interest in property. It's not a perfected security, because in order to perfect a security, you have to have judgment. You have to have a bodily attachment, which creates the debtor who's bound to perform to settle a debt. When he moved against them in an action, they went into foreclosure because they're trying to mitigate the risk on how much assets they're going to lose. And so if they're in foreclosure, during foreclosure, it creates an estoppel, which means that he won't be able to get paid anything necessarily. But because he has a statement of interest filed in the commercial chamber, when they do go to foreclosure after he gets his judgment, which should be relatively quick, then he would be able to go to the bankruptcy court and show his interest in the assets of the company. And when they liquidate, he would probably be, depending on how many other creditors are in line.
I'm number 17 on the list.
You're number 17.
So what I have is what they call the law contract. I don't have the original contract from the financing agency. I've asked for it, but they haven't mailed me anything other than just, the page of my actual purchase. They call it a law contract. So I can just go ahead and do an allonge on that.
You write to them and tell them that you want full disclosure of all documentation that was utilized in the transaction of account number ... whatever the account number is, right?
Yes, sir.
And give them 10 days to send that to you. Hey, I'm gonna give you 10 days plus 3 days grace period for the mail. Please send me. You can ask for certified copies. They may be able to do it, maybe not. Certified's great. If not certified, then copies of all the documents. So you're demanding full disclosure of the transaction.
Okay.
I'm writing you. This correspondence is in regards to account number XYZ, and I am inquiring or. You can demand if you want, but demanding
yeah.
I demanded. I'm sorry.
Maybe demanding is best, because if you're saying this inquiry is in regards to full disclosure, they may go, well, you can inquire all you want, because inquire is asking, but demanding is an inquiry, so you can demand. That
What I did was I demanded, and I also added silence is acquiescing to my default letter. So I added that in there, and they didn't respond to that either.
I like power plant fit over here. Command, not demand. You know, demand comes with liability of possibly being considered an order where you would have to pay for the cheeseburger you ordered versus command. I don't know what the ramifications or difference is, but it sounds good. Command versus demand.
Okay. Well, I appreciate your insight on that. I'll get started with it so I can just send out the 10-day notice certified and ask for request for all the documents.
The lawsuit is also correct. It's your account. You know, you can. It's my account. Give me the damn documents because it really is your account. Sure it is.
In regards to my lien, because I didn't get to finish that, because you were saying to go to a clerk, but I'm in arbitration, so there is no clerk.
Right. You agreed to arbitration, and so. Are you moving the arbitration, or is it the other party that's moving the arbitration? When's your next arbitration meeting?
December 13th. They informed the defendants to pay for everything.
To pay for everything as in what?
The fees for arbitration.
Yeah. They don't like that because they're a corporation, the arbitration companies charge the companies like $2,500 and they charge you what, $200, $300, something like that.
Well, they have to pay my fee as well. So
yeah, and then every time they come back, they end up paying more and more and more every time they come back if you guys can't come to an agreement.
But okay, so because they didn't respond, and I put them in default, and I slapped a lien on them. I'm not here to argue at this point. So how do I get them to pay what I asked for in the lien?
Well, how did you end up in arbitration? Surely that was a agreement that was made prior, right?
Well, it's a part of the provisions in my auto contract. And so when the lawyer finally came, he tried to get it into small claims court. And I quickly objected because...
Oh, shit, I'd let it in small claims court in a heartbeat because the only one that can go in a small claims court is somebody with firsthand perfected knowledge, and that lawyer's not allowed in there. I'd fucking welcome that.
He's not allowed in this matter anyway. He's infringing. Who is he? He's a third party. So I already hit him with breach of privacy because he sent me a copy of my auto contract, and I told him, well, how did you get this? I didn't consent to this.
Right. It's identity theft, yeah.
Yeah, I didn't consent to this. And so he's very arrogant, and I think I got him. You know, I already threatened him with a bar grievance.
Bar grievances are nice. You realize they have to self-report to their insurance company when you file a bar grievance. Whether the bar association does anything or not is irrelevant because they have to self-report, and it takes their insurance from $25,000 a year to $35,000 a year. And every bar grievance they get after that, it continues to rise. But after they get 3 bar grievances, they're forced to resign from being attorneys.
Right, and I already got 3 on him in this one case.
And you
breach.
Take 3 witnesses with you, and all 3 witnesses are witnesses to the same overt act, and every last one of them files a bar grievance, you can cause a career pathological liar to lose his bar card almost instantaneously.
Well, this idiot attached case filing to his threat against me, threatening to sue me, advised his clients to sue me, and I said, wow, this guy's crazy.
Say that again. He's advising his clients to sue you?
Yeah, he said once he saw the lien, he said he was going to advise his clients to sue me.
In lieu of what? If you don't do so, did he do the threat, duress, and coercion thing? If you don't do this, I'm going to advise. If you don't drop the lien, I'm going to advise my clients to sue you. Is that what he said?
No, that was his response, and he saying that the lien, he was going to be able to get rid of the lien or something
So
like
the other
that.
thing you should do is a UCC 11 at the Secretary of State's office to see if they even have a lien on record for your.
Oh, I already did that. I have zero resolve.
And then you want to go to the local county recorder's office and make sure they don't have a lien filed there. Because remember, they can file one of two places. They can file directly in the county at the county recorder's office, or they can file at the Secretary of State's office. They don't often opt to file with the Secretary of State. Most often we find the purported liens in the county recorder's office, but they're never backed by an affidavit, a statement of fact, and somebody testifying under the pains and penalties of perjury that, you know, the claim is valid. So they falsify a record on public record, which is a felony.
Okay, well, I would have to check that. They did send me a letter to my home saying that they bought the contract from the dealer and that they will be servicing it. And so my response...
Thank you for your admission that we don't have a binding agreement between you and I, dingbat. That's what I'd be telling.
Well,
thank you for your admission that we don't have a binding agreement or contract between the two of us, and that you bought that. Thank you so much for paying it and settling it. I want my assets back.
I added that to the case, but I hit him with, I forget which code, but I hit him with the code that specifically says that just because they purchase a contract doesn't mean they're allowed to enforce what's on it.
They call it the innocent purchaser. And the innocent purchaser has rights if he didn't have adequate notice or sufficient notice to know that what the innocent purchaser was acquiring wasn't, what is the language they use? It's getting late. But anyhow, it's basically where the innocent purchaser is protected due to the unknown factors, the fact that the first bank never actually paid you. Now, the first bank may have distributed the funds, but they distributed it possibly to the car dealership, and the car dealership should have given you those funds, but didn't.
Well, check what they did. I did my contract on the 17th of July. About a week later, I get some sort of email confirmation. Oh, thank you for signing. And I'm like, what? I didn't sign anything. What is this? So I open it up and it's some sort of power attorney document. So I immediately drafted a letter saying I did not sign any such document. And this is...
Is it notarized by chance?
Huh?
Was it notarized?
My letter that I made?
No, the document from them stating that you granted them power of attorney, is it notarized? Did they?
No, it wasn't.
Record and sign your name and then have some notary at the bank stamp off on it.
Yeah, it wasn't notarized.
See, we caught John Deere and Company with John Deere doing that, where they would forge people's name on a contract and then their in-house notary would stamp off on it. And we got a free and clear $98,000 excavator. It's a mini excavator, but still $90,000.
Here's the kicker, though. So my date on my contract was the 14th. The date on that forged document was the 15th. I wasn't there on the 15th.
Well, when you look at Title 15, 1692E, any false misrepresentation, that sounds like false misrepresentation to me.
But this is why they filed for bankruptcy.
From Switzerland.
What do you mean? Why? How'd you in?
Went that route.
Off naturally after 2.
But no, I don't think I need a power of attorney. Not from them.
So why not direct them from the beginning? Because why would they need a power of attorney? Because you're not giving them direction. So we'll take over and handle your business on your behalf because you're a...
All right.
But we got to remember this whole TikTok algorithm thing. We got to keep the live active. They don't count conversation. They don't count comments. It has to be likes, shares, followers, subscriber, and gifts. That's what they look for as activity. So yeah, Y'all tap the screen, share out the live if y'all are. You said they picky. Yeah, I don't know, because I be looking at some of these other people lives, but I also realize you got people that'll get on live and they ain't doing much of nothing, and they can get 100,000 likes in 30 minutes. So I think TikTok kind of weighs out what your live do according to stuff like that. So that's how they get to be on like that and don't get interrupted. Because people are liking and subscribing and giving gifts. You know, I look at all these people pretending to be AIs and stuff, you know, they can get on and have 14,000 people, you know, thousands and thousands and thousands of likes. And so when we get involved in conversations like this, if we're on for so long, they see the people, but no one is active. So we just got to learn how to play into their algorithm so we can keep the live going. So I'm hoping Mr. Derek them come back because the conversation was real good. Yes, Ruben, Mr. Derek is absolutely amazing. Absolutely. I wanted to finish getting the other gentleman's.
Private banking to produce monetary value for public and private trade. The ability to use the current system to obtain property or prosperity. It is important to understand just what our government is in order to operate effectively in the system. Did you know that it is actually a trust? Before explaining how the government is a trust, we will first examine a trust that most of us are familiar with, a deed of trust. You might be saying to yourself, you mean my mortgage? No, I mean your trust. Go to your filing cabinet and pull out your file on what you think is the mortgage to your home. Now, for the first time, read it. What does it say? Is a deed of trust different than a mortgage? Let's find out. The following definitions will be used from the Black's Law 4th edition and 6th edition. Trust, an obligation on a person arising out of the confidence reposed in him to apply property faithfully and according to such confidence as being in nature of deposition by which proprietor transfers to another property of subject in trust. Not that it should remain with him, but that it should be applied to certain uses for the behalf of the third party. Trustor, a person who creates a trust, also called a settlor. Trustee, person who holds title to the res and administers it for the other's benefit. One must be an attorney to operate a title company. If the title companies hold all the titles of the deeds of trust in the country, then who holds all the titles? That's right, attorneys. What's the definition for attorney? To attorn one's property and give to another. Beneficiaries, one for whose benefit a trust is created, one receiving benefit or advantage, or one who is in receipt of benefits, profits, or advantage. Beneficiary. Settlor, one who furnishes the consideration for the creation of a trust, though in form the trust is created by another. Did you know when you signed the deed of trust that you were giving benefit and advantage to the bank? Who created the deed of trust? The bank did. So why wouldn't the bank draw up the contract for their own advantage if we don't say anything against it? Mortgage equals a dead pledge or bet. The estate pledged becomes dead or entirely lost by failure to pay. An assignment or conveyance of land or house property to a person as security for the payment of a debt due to him, and on the condition that if the money shall be paid according to the contract, the grant shall be void. The Consolidated Webster's Encyclopedia Dictionary, 1939 edition. Most states have passed the Deed of Trust Act, And for the purpose of making it easier to evict people out of their homes by not going into court, why would they change the name of a mortgage to a deed of trust? Perhaps they are not holding the land or house property as security. What would the security be then? Deed of trust. An instrument in use in many states, taking the place and serving the use of a common law mortgage, by which the legal title to real property is placed in one or more trustees to secure the repayment of a sum of money or the performance of other conditions. Instead of having the land be security, the banks have replaced this with the legal title to real property. Does this mean a legal description? Can the legal description ever be the land or house property since there is no money? What would the performance of other conditions be? Could this be the delivery of the promissory note? Grant. To bestow, to confer upon someone other than the person or entity which makes the grant. Grantor, the person by whom a grant is made. Legal, conforming to the law according to law created by law. Private banking. To produce monetary value for public and private trade. The ability to use the current system to obtain property or prosperity. It is important to understand just what our government is in order to operate effectively in the system. Did you know that it is actually a trust? Before explaining how the government is a trust, we will first examine a trust that most of us are familiar with, a deed of trust. You might be saying to yourself, you mean my mortgage? No, I mean your trust. Go to your filing cabinet and pull out your file on what you think is the mortgage to your home. Now, for the first time, read it. What does it say? Is a deed of trust different than a mortgage? Let's find out. The following definitions will be used from the Black's Law 4th edition and 6th edition. Trust, an obligation on a person arising out of the confidence reposed in him to apply property faithfully and according to such confidence as being in nature of deposition by which proprietor transfers to another property of subject in trust. Not that it should remain with him, but that it should be applied to certain uses for the behalf of the third party. Trustor, a person who creates a trust, also called a settlor. Trustee, person who holds title to the res and administers it for the other's benefit. One must be an attorney to operate a title company. If the title companies hold all the titles of the deeds of trust in the country, then who holds all the titles? That's right, attorneys. What's the definition for attorney? To attorn one's property and give to another. Beneficiaries. One for whose benefit a trust is created, one receiving benefit or advantage, or one who is in receipt of benefits, profits, or advantage. Beneficiary. Settler. One who furnishes the consideration for the creation of a trust, though in form the trust is created by another. Did you know when you signed the deed of trust that you were giving benefit and advantage to the bank? Who created the deed of trust? The bank did. So why wouldn't the bank draw up the contract for their own advantage if we don't say anything against it? Mortgage equals a dead pledge or bet. The estate pledged becomes dead or entirely lost by failure to pay. An assignment or conveyance of land or house property to a person as security for the payment of a debt due to him, and on the condition that if the money shall be paid according to the contract, the grant shall be void. The Consolidated Webster's Encyclopedia Dictionary, 1939 edition. Most states have passed the Deed of Trust Act, And for the purpose of making it easier to evict people out of their homes by not going into court, why would they change the name of a mortgage to a deed of trust? Perhaps they are not holding the land or house property as security. What would the security be then? Deed of trust. An instrument in use in many states, taking the place and serving the use of a common law mortgage, by which the legal title to real property is placed in one or more trustees to secure the repayment of a sum of money or the performance of other conditions. Instead of having the land be security, the banks have replaced this with the legal title to real property. Does this mean a legal description? Can the legal description ever be the land or house property since there is no money? What would the performance of other conditions be? Could this be the delivery of the promissory note? Grant. To bestow, to confer upon someone other than the person or entity which makes the grant. Grantor, the person by whom a grant is made. Legal, conforming to the law according to law created by law. Private banking. To produce monetary value for public and private trade. The ability to use the current system to obtain property or prosperity. It is important to understand just what our government is in order to operate effectively in the system. Did you know that it is actually a trust? Before explaining how the government is a trust, we will first examine a trust that most of us are familiar with, a deed of trust. You might be saying to yourself, you mean my mortgage? No, I mean your trust. Go to your filing cabinet and pull out your file on what you think is the mortgage to your home. Now, for the first time, read it. What does it say? Is a deed of trust different than a mortgage? Let's find out. The following definitions will be used from the Black's Law 4th edition and 6th edition. Trust, an obligation on a person arising out of the confidence reposed in him to apply property faithfully and according to such confidence as being in nature of deposition by which proprietor transfers to another property of subject in trust. Not that it should remain with him, but that it should be applied to certain uses for the behalf of the third party. Trustor, a person who creates a trust, also called a settlor. Trustee, person who holds title to the res and administers it for the other's benefit. One must be an attorney to operate a title company. If the title companies hold all the titles of the deeds of trust in the country, then who holds all the titles? That's right, attorneys. What's the definition for attorney? To attorn one's property and give to another. Beneficiaries. One for whose benefit a trust is created, one receiving benefit or advantage, or one who is in receipt of benefits, profits, or advantage. Beneficiary. Settler. One who furnishes the consideration for the creation of a trust, though in form the trust is created by another. Did you know when you signed the deed of trust that you were giving benefit and advantage to the bank? Who created the deed of trust? The bank did. So why wouldn't the bank draw up the contract for their own advantage if we don't say anything against it? Mortgage equals a dead pledge or bet. The estate pledged becomes dead or entirely lost by failure to pay. An assignment or conveyance of land or house property to a person as security for the payment of a debt due to him, and on the condition that if the money shall be paid according to the contract, the grant shall be void. The Consolidated Webster's Encyclopedia Dictionary, 1939 edition. Most states have passed the Deed of Trust Act, And for the purpose of making it easier to evict people out of their homes by not going into court, why would they change the name of a mortgage to a deed of trust? Perhaps they are not holding the land or house property as security. What would the security be then? Deed of trust. An instrument in use in many states, taking the place and serving the use of a common law mortgage, by which the legal title to real property is placed in one or more trustees to secure the repayment of a sum of money or the performance of other conditions. Instead of having the land be security, the banks have replaced this with the legal title to real property. Does this mean a legal description? Can the legal description ever be the land or house property since there is no money? What would the performance of other conditions be? Could this be the delivery of the promissory note? Grant. To bestow, to confer upon someone other than the person or entity which makes the grant. Grantor, the person by whom a grant is made. Legal, conforming to the law according to law created by law. Private banking. To produce monetary value for public and private trade. The ability to use the current system to obtain property or prosperity. It is important to understand just what our government is in order to operate effectively in the system. Did you know that it is actually a trust? Before explaining how the government is a trust, we will first examine a trust that most of us are familiar with, a deed of trust. You might be saying to yourself, you mean my mortgage? No, I mean your trust. Go to your filing cabinet and pull out your file on what you think is the mortgage to your home. Now, for the first time, read it. What does it say? Is a deed of trust different than a mortgage? Let's find out. The following definitions will be used from the Black's Law 4th edition and 6th edition. Trust, an obligation on a person arising out of the confidence reposed in him to apply property faithfully and according to such confidence as being in nature of deposition by which proprietor transfers to another property of subject in trust. Not that it should remain with him, but that it should be applied to certain uses for the behalf of the third party. Trustor, a person who creates a trust, also called a settlor. Trustee, person who holds title to the res and administers it for the other's benefit. One must be an attorney to operate a title company. If the title companies hold all the titles of the deeds of trust in the country, then who holds all the titles? That's right, attorneys. What's the definition for attorney? To attorn one's property and give to another. Beneficiaries, one for whose benefit a trust is created, one receiving benefit or advantage, or one who is in receipt of benefits, profits, or advantage. Beneficiary. Settlor, one who furnishes the consideration for the creation of a trust, though in form the
without any hassle, because I know that
properly construed in the favor of the consumer. As used in the subchapter, the term accepted card or other means of access means a card, code, or other means of access to a consumer's account for the purposes of initiating electronic fund transfers. When the person to whom such card or other means of access was issued has requested and received or has signed or has used or authorized another to use such card or other means of access for the purpose of transferring money between accounts or obtaining money, property, labor, or services. Title 15, U.S. Code 1693A, definitions. Yep, welcome to the 21st century. Electronic fund transfers. The term account means a demand deposit, savings deposit, or other asset account other than an occasional or incidental credit balance in an open-end credit plan as defined in Section 1602I of this title, as described in regulations of the Bureau, established primarily for personal, family, or household purposes. That's right. Amen. Security obligation of the United States, because it's for the consumer, the natural person, for personal, household purposes, right? It's not engaged in commerce or agriculture or industrial uses and purposes. So this is a consumer credit transaction.
Someone said it might as well be in a different language, but it gives you the definition of the words.
No, it gives you the terms of the words. Them ain't definitions. Go look at it. It says term. Terms and definitions are two different things.
Right.
This is a term that is defined specifically for this section. The term account means a demand deposit, savings deposit, or other asset account other than an occasional or incidental credit balance in an open-ended credit plan. All right, open-ended credit plan means that your application is a revolving line of credit. And to my studies, that open-ended line of credit, that juristic person, when they open that account, is a 75-year charge up. They charge it up 75 years into the future. Whether or not that's true, I cannot conclusively prove that. But what we do know is that the juristic person is considered to be retired at 75 years. Bareboat Charters is where I learned that information. In case anybody was, you inquiring minds were wondering where I got that information, I was reading about bareboat charters and the law of merchant, and they stipulated that there was a 75-year policy in effect for bareboat charters. And I actually got that from they're very hard volumes of books to get. They're like $14,000. It's called the Benedicts and Admiralty, and it's allegedly what judges use from the bench. It's called Benedict's Admiralty. I think the 39-volume set is like upwards of $18,000. And the online, they update it 3 times a year. The online version is like something like 30 grand. It's fucking ridiculous. It's nuts. It's got the law of salvage and all that good stuff. It's all maritime admiralty. The term board means the Board of Governors of the Federal Reserve. The Bureau means the Bureau of Consumer Financial Protection. And when you go look at the Board of Governors of the Federal Reserve, they all purport to be to enforce Title 15 as well. So even though it's not enacted into positive law, all these agencies directly point back to the language out of Title 15. The term business day means any day on which the office of the consumer financial institution involved in an electronic fund transfer are open to the public for carrying on substantially all of its business functions. Term consumer means the natural person. Yeah. The power of that, the natural person.
I appreciate you reading that.
Sorry, is that so? Natural person, is that no longer the person that they describe as a corporation or business or whatever?
The natural person is the highest capacity and conduit you can operate in commerce. It's above creditor. It's above debtor. It's the natural person. It's the highest capacity one can operate in commerce with.
Gotcha.
A natural person is a consumer, and a consumer is a natural person. And they're both fictions. They're both a conduit by which you can see, because when they write you and you allegedly owe a debt, they say, "Dear debtor." Well, that's slandering and defaming language. That's obscene and profane language, which is a violation of Title 15, 1692. E, if I recall correctly. And, or might not be under E, might be ABC. It might be under D, harassing language, that of which is intended to harass, oppress, or abuse the reader or hearer, right? So when they say, "Dear debtor," if you don't rebut and rebuke that, guess what? By presumption and assumption, you become the debtor.
You accept.
I write them back, let them know, I don't know who the fuck you calling a debtor, son of a bitch. I'm the consumer natural person. You were in direct communication with a consumer natural person inquiring on where you got your express written consent to communicate with the consumer. Who the fuck are you guys? And how'd you get my private intellectual property? Right? I'm dead serious. You guys are laughing. That's a win-win right there. You could take them,
right.
take them for $1,000 right there just for them calling you a fucking debtor.
Oh, am I slipping?
Mm-hmm. Young ladies out there, every time they write to you and they say, "Dear debtor," I want you to think of the word C-U-N-T. They just called you a C-U-N-T. You better get after them asses. You better get after them. Don't let that shit get out of control.
Damn, even worse.
Right?
No. Right? The term electronic fund transfer means any transfer of funds. Any. And you have a full right to the disclosure of the nature and cause of the transaction, which means you have a right to a full accounting. How much did they access the estate for? Oh, well, we don't divulge that information. Well, you going to today, Junior? You going to today? Because you're either going to give it to me today or I'll subpoena that shit. And we're going to find out. We're going to get down to the bottom of it. Because that account is at bare minimum FDIC insured for $250,000. Bare minimum. That's not to mention the life insurance policy they got on your ass because you open an account with them, and every banking institution immediately when you create an account goes out and gets a whole life insurance policy on you.
Yeah.
Best game in town. Other than
my ex texted me the other day, I was like, "No debtor, no debtor." Fuck. Damn, that's so crazy, man. This fuck.
Other than a transaction originated by check, draft, or similar paper instrument, which is initiated through an electronic terminal, telephonic instrument, or computer or magnetic tape, so as to order, instruct, or authorize a financial institution to debit or credit an account. Such term includes, but is not limited to, point of sale transfer, automated teller machine transactions, direct deposit or withdrawal of funds, and transfer initiated by telephone. Such term does not include any check guaranteed or authorized service which does not directly result in a debit or credit to a consumer account. I'm telling you right there. It's all to a consumer's account. Whose account is it? It's the consumer's account. So do you have a right to the information? Yes, you do. Yes, you do.
Derek?
I'm reading. Yeah, go ahead.
What was the name of that code again?
This is Title 15, 1693.
No, what you were reading before that. Where it talked about the natural person.
That was it?
It's in 1693 in the definitions.
Oh, okay.
Uh-huh. See, why I like 1693 is it's Congress peering into the future, because it tells you in their declaration that, well, I'll just read it. We'll just take all the hyperbole out of it. So Title 15, U.S. Code 1693, Congressional Findings and Declaration of Purpose, Rights and Liabilities Undefined, that Congress finds that the use of electronic systems to transfer funds provided the potential for substantial benefits to consumers. Again, it's for the substantial benefits of the least sophisticated consumers, right? It's for the consumer's benefit, not for the corporation's benefit. I keep pointing that out because this is the congressional declaration and findings of their intent and purpose. And I see a lot of lawyers that use this in a courtroom to destroy people, and it's all right here in their declaration and finding of facts what the intent is, and nobody ever uses it. However, due to the unique characteristics of such system, the application of existing consumer protection legislation is unclear. So they're telling you right now, it's unclear. The path going forward in the electronic fund transfer after the 2017 Electronic Transfer Act was passed, that we're in uncharted waters. So what are they going to say? Leaving the rights and liabilities of consumers, financial institutions, and intermediaries in electronic fund transfers undefined. So let's find out what their whole purpose for letting us know all that shit was, right? It is the purpose of this subchapter to provide a basic framework establishing the rights, liabilities, and responsibilities of participants in electronic fund transfers and remittance transfer systems. The primary objective of this subchapter, however, is the provision of individual consumer rights. So they just told you what their intent and purpose was of this whole chapter is the individual consumer rights. And that goes for 1601 through 1693. It's all about the consumer, and it's about the way they go about attempting to collect the debt. Don't have anything to do with the debt. It's the way they go about it that you get to hang them up. They violate the law, and you get to string them up for it.
All right, y'all. Let's tap the screen a little bit. Let's tap the whole screen of just a little bit, probably 30 seconds, y'all. Let's put hashtag FYP in the comments. Hashtag FYP in the comments, y'all. Y'all, I'm exhausted. I'm sorry, I'm tired, but that man's voice, I just can't go to sleep. I could go to sleep to his voice, I think. But yeah, he be dropping it on us, you know. I know he exhausted.
You know he is.
Yeah, he been doing this all day, y'all. All day.
All day. We ain't even broke down an entire section of the FDCPA. We've been bebopping on how. But that's how it goes.
You go and you study this, y'all. You go and you study and you understand.
Mm-hmm. All you really have to understand is that they've completely perverted the system, turned it 180 degrees upside down and backwards. And all you have to realize is that your over-the-counter security is the money. And they're taking your over-the-counter security as a security intermediary and trustee, an application, which is a collateral security of the United States, and they are shopping it around to all these different venues, trying to find out who the highest bidder will be, even though they're only entitled to a transaction fee. And every bank that they shop your information around to, they're getting a kickback from, which that's illegal. If they're even getting one penny from shopping around your information, that's an illegal conversion. And they're your agent. They're supposed to be working for you, but they really aren't, because people don't know what's going on. And so they find a bank, says, oh, yeah, we'll do that deal. And they take that security and throw it over to the bank. And then the funds are transferred to the dealership. But you were never paid. And if you go and look I believe it's the document with the odometer reading is where the car dealership in particular grants to the grantee, and it's not for any value of money or anything. It's just a grantor to a grantee relationship. So the car has nothing to do with the transaction at all. The car absolutely has nothing to do with it. And everybody's so stuck on the shiny shit. It's a perfect distraction.
Contract is not the collateral, which they deem the collateral is not the collateral. The contract is the collateral.
Right. The application with the tender is the collateral. But they convince people that they take advantage of the people that don't know that that's the case. And so what ends up happening is they put before them a retail installment contract wherein if you read down past the finance charge and APR and all that good jazz, and you read down just a little bit, it ain't very far, it'll say that you agree to give collateral interest or security interest in the automobile, and it'll have the VIN number. And then further on down, it'll say you also agree to give us all rights, titles, interest, dividends, all interest in all rights, titles, interest, and dividends, derivatives of any kind. And at that point, I want you to ask yourself, how do you give them a collateral interest in something you don't own? Because remember, they've got you convinced that you got a loan to get the automobile. Well, if you got a loan to get the automobile, you never paid for the automobile. And if you never paid for the automobile, how could you pledge it as collateral security for a retail installment agreement? Mm-hmm. You couldn't. Do you know there's no law that requires you to sign that retail installment agreement? There is no law. There is no law that requires you to sign a mortgage. As soon as they run that credit app and they come back to you and say, hey, congratulations, you've been approved. Great. It's keys to my fucking car. Where's the keys to my house? There's no law that requires you to sign any of that shit. As soon as they tell you you've been approved, that's a done deal.
Transaction over.
Pay the invoice to the dealer. Pay the security agreement to the borrower. Have them issue a letter of satisfaction and a release of lien interest. And you always have your right of rescission under Title 15, 1635, but you're not doing a rescission of the note. You're doing a rescission of the security agreement. But what's your purpose? See, people say, "Oh, I'm doing a rescission," and the courts ignore them. Why? Because they didn't give them a reason. What was the reason for it? The reason for it was the fact that they failed to perform within the first 24 hours, granting rise to you doing a rescission at no fault of your own because of their failure to perform.
Fucking Derek.
And the judges do installment contracts every day. And they send people to county jail and send people to prison. That's an installment contract. So it's no different from jail or prison to the car lot to the title company. It's all installment contracts. And they're all doing the dead pledge, the 30-year mortgage, the 5-year leases, all the installment contracts. How you buy your car, 7 years, 5 years, 3 years, however you lease it, sell. It's all the same thing. It's all installment contracts.
All the same.